our webinar today regarding COVID-19 vaccinations, employers' options for compliance with the EEOC and CDC and OSHA. I'm joined by my colleague, Robert Ayers. Robert, say hello.
Hi, thanks, Brett. Hi, everybody. Robert Ayers, I co-lead our workplace safety and emergency response practice located out of our Jackson office. A large part of my practice is responding to government inspections and compliance counseling on the very things that we'll be talking about today. So looking forward to it.
So here I'm figuring out the slides. There we go. So today's presentation, we've kind of broken down into four primary areas. We're going to talk about mandatory vaccination and the guidance received from the EEOC, as well as some state law issues relating to mandatory vaccination policies. Robert will talk to us about the CDC's guidance as well as OSHA's guidance. And then we're going to have a segment dedicated to healthcare employers, because obviously this issue of vaccination is significantly important for healthcare employers as well. So those are our four main topics today. So let's dive right in. First of all, I want to emphasize that although we're going to spend time talking about federal discrimination law and compliance with EEOC guidance, the developments that you must pay attention to are happening on the state law level on these issues. You will always have to comply with federal law, but you may be required to comply with state law that is stricter or more restrictive of your options than the federal law is. There are approximately 42 states that have considered bills banning mandatory or limiting mandatory vaccination policies, either in their last legislative session or they are currently teed up for consideration. For instance, in Wyoming, the Joint Labor Committee last week adopted a draft legislation that will be considered in the 2021 legislative session that would make it an unfair employment practice to require vaccination for employers. Montana, if you're not in the healthcare sector in Montana, it is already illegal, or I'm sorry, it will be effective July 1st. It will be illegal for you to require mandatory vaccinations as an employer in Montana. The Colorado and Idaho legislative committees considered bills in their last session. Both of those died in committee. So this is a big area of state legislature activity. So you need to pay attention on a state level in your state as well as at the federal level. So let's dive into the EEOC guidance. On May 28th at about 6:00 p.m. Eastern time, the EEOC, Friday, May 28th, the EEOC issued its guidance about mandatory vaccines and other related topics. So it made for a long holiday weekend. In any event, the EEOC said that employers can have mandatory vaccination policies. You can require the vaccine, all your employees to be vaccinated. The question then that this poses for employers is whether you should adopt a mandatory vaccine policy. I think the answer to that question will vary from employer to employer, from industry to industry, as you consider the pros and cons for your particular workplace. I've seen studies or analyses that suggest that between 8 and 10% of employers are adopting mandatory vaccination policies. I know from our own client experience that we have obviously clients in healthcare that are adopting the policy. We also have some clients in things like software development industry that have developed and adopted a mandatory vaccine policy. So it's a small number of small percentage of employers that are doing it. But if you do, you have to be ready to ask the tougher question, which is, are you willing to terminate an employee for refusing to be vaccinated when they do not have a disability or religious belief accommodation? We'll get to that question, but that's really the rubber hits the road question for whether to have a mandatory vaccine policy. The other difficult topic that the EEOC guidance presents us with is knowledge of the vaccination status. The guidance says very clearly that employers can ask the question, are you vaccinated, and can require employees to submit documentation of their vaccination. The question about vaccination status is not a medical examination or a disability-related inquiry, which would be prohibited except under limited circumstances under the Americans with Disabilities Act. So the EEOC gave us that bit of guidance in their latest guidance, but they then said that the status and the documentation is confidential medical information under the ADA. So while you can receive that information, you can ask for it and require employees to respond to you, you can't share that information internally. You can't release it as an employer. The older EEOC guidance about medical information in general tells us that supervisors cannot have access to the medical information, but they can be told what restrictions and accommodations are caused by the unspecified medical information. So as we consider what this means for your vaccination policy, you're not able to, or you shouldn't, according to the EEOC, tell supervisors who's been vaccinated and who hasn't, but you can tell supervisors who should wear the mask and who isn't required to. So that's an interesting distinction that the EEOC has baked into this most recent guidance. It's also probably the least helpful aspect of that guidance, and probably one that most employers will have a hard time complying with, simply because it's far easier to talk about whether you're vaccinated than to ask whether you are required to wear a mask in the abstract. The guidance addressed some considerations when the employer provides the vaccine. So this guidance applies when the employer requires employees to be vaccinated and provides the vaccine either on the employer's premises or through a contractor that the employer has arranged for the vaccination. When that happens, the employer will necessarily ask screening questions for the vaccine. The CDC has developed a series of screening questions before somebody gets the vaccination that talks about allergic reactions. It asks about some particular conditions the employee may have that may make the vaccine either not as effective or may be contraindicated. So there are screening questions that are disability-related inquiries. If the employer is asking those questions and requiring on threat of termination those questions, then the employer must be able to prove that the questions of a particular employee are job-related and consistent with business necessity. That essentially means that the employer has to have objective evidence that that particular employee who refuses to answer the questions and will not get the vaccine will pose a direct threat to the health and safety of others. So when the employer is providing the vaccine and doing so either directly from the employer or by a contractor, this is a consideration that the employer needs to take into account before disciplining or terminating an employee who is refusing to answer the questions or get the vaccine. This does not apply to vaccination policies when the employer allows employees or encourages employees or requires employees to go to a third party, to go to a clinic or a pharmacy to obtain their vaccination. Let me let you know if you have questions as we go along. You can use the chat function in the webinar app and send your questions in that form. We will try to address as many of those as we can when we're finished. So if you have a mandatory vaccination policy, or even if you have a strongly encouraged vaccination policy, you will get objections from employees. I don't believe I have a client who has stepped into this area from a policy perspective who has not received a variety of objections from the employees who don't want to have the vaccination. For our purposes, for the next few minutes, let's separate those objections into those that have legal significance and those that do not. The ones that have legal significance are based on religion and disability. Title VII of the Civil Rights Act requires that employers accommodate sincerely held religious beliefs, practices, or observances. The Americans with Disabilities Act requires that employers accommodate disabilities. So when you hear objections based on a religious belief or something that the employee contends is a religious belief or a medical reason, those require the interactive process, and they require a thorough analysis by the employer. When you hear objections based on vaccines don't work, or I don't take medications or vaccines into my body for other kinds of reasons, those are not as legally significant and are not necessarily, do not necessarily trigger the accommodation requirement as long as they're not tied to religion or disability. So, sincerely held religious belief, practice, or observance. The law requires that the employee must explain the religious nature of their belief and how it conflicts with vaccination. The difficulty employers face here is that the law is very clear that religion is defined very, very broadly for Title VII protections. It does not require a mainstream religion, doesn't have to be well known, doesn't have to have a building, doesn't have to be organized, and the employee can be the only person who believes in the religious belief. There doesn't even have to be a group or a leader or anything like that for it to be a valid religious belief that requires accommodation. Title VII protects moral or ethical beliefs as to what is right and wrong, and which are sincerely held with the strength of traditional religious views. That's how what courts have developed as the standard for the Title VII protection of a religious belief. We know from cases involving the influenza vaccines that general objections to vaccinations or specific objections to a particular vaccination are usually not sufficient. They have to be coupled with more of a spiritual system of belief, and so just the I don't like vaccines approach isn't going to support that requirement of accommodating a religious belief. Now, the EEOC in their guidance said that the employer should assume the validity of the belief and question only when objective evidence exists to the contrary. That is not how courts have interpreted the Title VII accommodation requirements. The EEOC is taking a very pro-employee position on this point. I do warn you that it is fraught with peril. So when you are making decisions about accommodations from a religious belief, you should involve your counsel and go forward very carefully. If in fact there is a religious belief system, you may be required to accommodate that. The accommodation under Title VII is required when it does not pose an undue hardship on the employer. This is not the same test as under the Americans with Disabilities Act, which addresses undue burden and is a much stronger standard. Under Title VII for religious accommodations, the courts have said that the employer does not need to provide accommodation that generates more than a minimal cost or burden for the employer. So that's a pretty low threshold, but again, it's not, it's still a threshold. It's not something you can simply ignore and claim that you have a cost or a burden. Potential accommodations include all the things we did to slow the spread of the virus before there was a vaccine, as well as things like reassignment to another position to lower the risk, shift changes, perhaps remote work. All of those things are potential accommodations for a religious belief that conflicts with the vaccination requirement. The disability accommodation under the Americans with Disabilities Act is a different process. The interactive process is similar, but the standards and thresholds are different. The employee has to come forward. They have to identify the disability and request an exception. The EEOC made it clear that even fully vaccinated employees may request an accommodation related to their vaccination status if they're immunocompromised. And Robert will talk a little more about that from the OSHA perspective. When an employee comes forward, you then pursue the interactive process. You can request documentation of their underlying health condition. You can request an explanation by their health care provider of the reason why the vaccination is not appropriate for them. And then you need to consider if those two requirements are met, you need to consider what accommodations are available for that employee in their position. Undue burden is an exception to the accommodation requirement, but under the Americans with Disabilities Act, it's a much more difficult standard than it is under Title VII. It's defined under the ADA as significant difficulty and expense considering the employer's resources. So the larger you are as an employer, the more difficult you will have, the more difficulty you will have in proving that you're entitled to an undue burden exception to the general duty to provide reasonable accommodation. In litigating ADA cases for many, many years, I've only very rarely seen undue burden defenses successful in ADA cases. The other exception to the accommodation requirement under the ADA is the direct threat. And if an employee is not willing to be vaccinated or cannot because of a disability, and you determine that allowing the employee to continue to work poses a direct threat to the health and safety of others, you can refuse to allow that employee to continue to work. Some caveats there. You have to consider whether the risk can be reduced or eliminated, reduced to an acceptable level or eliminated by reasonable accommodation. And ultimately, the employer bears the burden of proving that the direct threat existed and could not be eliminated by accommodation. Again, you have to base this conclusion not on some general policy or some general stereotypical idea about which positions in your organization have to be vaccinated, but it has to be an individual assessment based on current medical knowledge and reasonable medical judgment. So in other words, it's not just your policy. Your policy is not going to do it. If you're going to claim a direct threat, it has to be very employee specific, and you have to consider these factors: duration of risk, the nature and severity of the potential harm, likelihood of harm, imminence of harm in relation to that employee's job and that employee's workplace activities. So this is not a policy level decision when accommodations are requested. It's an employee by employee decision, and it has to be done at that level. Pregnancy accommodations are also going to come up in the context of your vaccination policy. This is not an ADA issue because pregnancy is not a disability. Prenatal complications are usually not a disability. They could be, depending on the underlying condition, but oftentimes they're not. So the rule is with pregnancy-related objections, you have to treat those like any other temporary medical condition. So if you would provide short-term leave or some other measure for some other kind of medical condition that another employee has, you have to do a similar thing for pregnant employees. So if an employee who is pregnant does not wish to have the vaccination because of some of the information out there about pregnancy and the vaccination, you have to consider whether there's something you can do during the time period that the employee is pregnant during that temporary medical condition. I suggest that you consider this like an accommodation, even though it's technically not, because pregnant moms are very sympathetic plaintiffs. You want to fire a mom on the, prior to them giving birth. I can assure you that is a high risk maneuver. So you need to think about that carefully. The EEOC guidance suggests some incentives for vaccination. You can read several accounts of different employers and what they're doing to incentivize vaccination. Up to, I guess Kroger offered $100 bonus for vaccinations, and they gave $100 to people who substantiated an accommodation under Title VII or the ADA. So they put their money where their mouth is on that policy. There's a variety of different incentives that have been offered. If you are not providing the vaccination directly or through someone you've contracted with, then you can you can use incentives without really much consideration of the EEOC's guidance. If you are, however, providing the vaccination, this goes back to those disability-related questions, those screening questions I talked about earlier. If you're asking the screening questions and you're providing a substantial incentive, the EEOC says that it might be coercive. You might be coercing employees who have a right not to give you disability-related information by the size of the incentive. Now, the EEOC doesn't tell us what size of incentive is coercive. They simply say that your incentive, if you're providing the vaccination directly, your incentive should be not so substantial as to be coercive. So that remains to be seen when from the EEOC's efforts to enforce that guidance later on, or from lawsuits down the road, what exactly that means. So as you think about implementing a mandatory vaccination policy, there are clearly going to be some components of that policy. You're going to have the carrot, which is taking the mask off, right? I mean, that's everybody's carrot when it comes to vaccination, and being able to work during the day without the mask and without the social distancing requirements. You're going to have a stick. And the stick is going to be, you're either going to be terminated or disciplined, or you're going to have to continue to wear masks and be socially distant, and take other measures that the employer might provide. Then you have to think about enforcement. If the vaccination status is confidential medical information per the EEOC. So you can tell supervisors who can wear a mask, who needs to wear a mask, and who doesn't, but you can't tell them why. You can't say that person's vaccinated or that person's not. So supervisors who are trying to enforce the policy, trying to continue to enforce the CDC guidance and the OSHA requirements that Robert's going to talk about, are kind of at a loss under the EEOC's guidance, because they have to, they have to rely on kind of a changing list of people who may or may not be required to wear masks. So, you've got to address that lack of knowledge on the supervisor's part, I think, as you think about how to implement your policy. Stickers and name badges. Several employers that I'm aware of are using a sticker on the name badge for vaccinated employees, or a special name badge, or some sort of special designation on something that everybody wears. And I think that's a really good idea. The EEOC guidance would suggest, they didn't specifically address those methods, but they say that you cannot require employees to tell people whether they're vaccinated or not. But there's nothing that keeps employees from volunteering to do so. As you consider and implement that sort of a policy tool, I just suggest that you strongly encourage and tie that with the notion that if you don't, if you don't let people know, if you're not willing to wear the sticker or whatever, these are your limitations on your activities. These are the things you must continue to do within our workplace. In the course of drafting a policy, I think it's going to be very important to include your processes for accommodation requests. I think you need to educate employees in the policy that there are religious grounds. There may be religious grounds for an exception. There may be disability-related grounds for an exception, or pregnancy-related grounds. Your vaccination policy needs to be consistent with and incorporate your other kinds of policies, your disciplinary action policy, and any other policies that might implicate that, perhaps your safety policies. I suggest that you communicate in the context of your policy your legitimate business reasons for it, and that you make the case for why this vaccination policy is important for your particular workplace. I've seen some vaccination policies that say we're doing our part to stop the spread of COVID in our community. Well, okay, a perfectly valid concern for a business as a community member. That does nothing to help me or to help your counsel defend your policy in a lawsuit, because the way these things are going to be challenged under the ADA or under Title VII, they're going to be challenged based on the very unique circumstances of that employee in your workplace, not as a community member. So, so you need to focus in your policy on why us, why here, why you, and explain that in some degree of detail. By the same token, don't assume every position poses the same risk and requires the same policy response. Work locations may be different. Certain jobs may be different. You know, the place where people work may be different. So analyze this on a position by position basis and be ready to defend it on a position by position basis. And then we need to protect people who are not going to be vaccinated for any of the legitimate reasons, and some people who may not choose to be vaccinated for reasons you don't think are legitimate. It is inappropriate for employees to ask other employees why they have not been vaccinated, because that will lead for some of those employees to pressure to disclose disability-related information or religious information. So the policy needs to prohibit any negative treatment or any questioning of a person who is not vaccinated about why they're not. And HR will need to address those things as they come up. So ultimately, can you fire an employee for refusing to vaccinate? And this is where the rubber hits the road, because you're not going to face significant liability risk until someone gets fired or laid off because they refuse to be vaccinated. But your policy isn't going to have any teeth unless your policy says that can happen. So, you know, I don't see how you have a policy that says this is mandatory and you need to do it, but if you don't, we're not sure what's going to happen. I think if you're going to have a mandatory policy, this is the logical result. We are seeing lawsuits already challenging terminations for refusing to be vaccinated. There's been 3 against public employers. North Carolina, New Mexico, California were all public employers. Those are ongoing. The Texas, the Houston Methodist case out of Texas was dismissed, and we'll talk about that in a second. There are common themes to these. One of them is that you know, they're all kind of state law claims of public policy violations to require somebody to be vaccinated. Another common theme is that that the emergency use authorization regulation that governs the FDA's granting of emergency use authorization says that individuals are to be informed of the option to accept or refuse the administration of the product and the consequences, if any, of refusing administration of the product. So some very creative plaintiffs' lawyers have said that this FDA regulation prohibits mandatory vaccination policies because it says right there that employees have the option. Well, the judge in the Houston Methodist case decided that was not a persuasive argument. So let me just touch on this case before I turn it over to Robert. Houston Methodist is, of course, a healthcare system in Texas. They're a private healthcare system, which may end up being significant. They adopted a mandatory policy, and they included all the required accommodation exceptions of 26,000 employees. All but 117 were vaccinated or had established accommodations. The remainder, that 117, refused to be vaccinated for various reasons unrelated to religion or disability. They filed a lawsuit, and they brought some state law claims. They brought a claim based on the emergency use authorization language. There's a statute governing when human drug trials can be done and how they can be done. They brought a claim under that statute. Then they brought a creative claim under the Nuremberg Code that essentially was adopted after the Nazis performed medical experimentations on Jewish people in the extermination camps. So the judge, in about a 5-page opinion, dismissed all of these claims. And his basic dismissal reasoning is quoted there. Bridges, who is the named plaintiff, can freely choose to accept or refuse a COVID-19 vaccine. However, if she refuses, she'll simply need to work somewhere else. That opinion, that decision's been appealed to the 5th Circuit already. And so we'll see how Houston Methodist develops in the appellate courts. I expect we're going to see many other lawsuits and this along with the state legislatures, where the development of the law of mandatory vaccines will continue. We've had those lawsuits in the healthcare field related to influenza vaccines, and they've had some mixed success, but also, several of them have been dismissed. So we'll see how this develops with respect to a vaccination that was required under an emergency use authorization. So I'll turn it over to Robert.
Thanks, Brad. So we're going to start with the CDC, and let's start with the good news. As I believe everyone on this presentation knows, the CDC has stated that fully vaccinated individuals can resume activities without wearing face coverings or physical distancing. Obviously, this is subject to federal, state, and local requirements. Some of those we're going to talk as we go through, but this was at least the first major movement in allowing those other, especially at the state and local level, rules to start being relaxed. So that's our first big change. I think a lot of the things we're going to talk about today are really keyed off of. The CDC guidance also allows for fully vaccinated individuals to refrain from quarantine following a known exposure, as long as they remain asymptomatic. So in other words, if you have somebody in your workplace that is fully vaccinated and they come into close contact, right, 6 feet for 15 minutes over a 24-hour period, they're not going to have to move into that quarantine. At least this is what CDC is saying. You're not going to have to move into that potentially 14-day quarantine period if you are fully vaccinated. You can also refrain from routine screening if that's feasible given your workplace. In other words, if you're having required screening, maybe even required testing, if you're fully vaccinated, the CDC is saying you can refrain from engaging in that routine screening. As a matter of policy, I still think it's best if your workplace has a self-screening requirement to continue everybody to do that, but it depends on your workplace and what level of burden that is on those employees. So when are you fully vaccinated? Again, I think this has become common knowledge, but it's 2 weeks after you've completed your vaccination. So if it's a two-part, it's 2 weeks after your second dose. If it's the J&J, it's 2 weeks after that single dose. There's been slight updates, but we're generally the same as we've been over the past several months. The CDC is still recommending that unvaccinated workers wear a face covering, that they remain physically distant, certainly that they stay home if they're experiencing any COVID-19 symptoms, and certainly if they test positive for COVID-19, to quarantine following that close contact. We just talked about unvaccinated or fully vaccinated individuals now no longer have to do that per CDC, but if you're not fully vaccinated, you're still going to have to go through that quarantine process. Then also to practice good hygiene and to clean and disinfect your routine, high frequently touched areas. On the employer side, this is just, these 3 bullets are a very short list of what CDC is saying you should do as an employer. But again, largely unchanged from an unvaccinated perspective. You're going to need to encourage sick employees to continue to stay home. For unvaccinated, you're going to need to continue to conduct health screenings, or as we talked about earlier, require those self-screenings. And so when I say self-screenings, what we're really talking about is you have a policy that says, hey, employee, any time before you come into our office, any shift, any day, you need to check yourself for these 10 symptoms and make sure you don't have any of them. If you do, don't come in, call HR, right? That's that self-screening process. And employees are also need to continue to clean and disinfect frequently. When we say disinfect, what we're referring to there is EPA approved disinfectants, and the CDC has a link to on their website has a link to EPA that you can just follow them, but CDC has good recommendations kind of step by step for how to do that disinfecting process. So what do you do if you have a positive COVID case in the workplace or asymptomatic, right? So a suspected case, maybe the person hasn't tested positive yet, but they are showing significant symptoms of COVID-19 and they believe they have it, or it's strongly suspected that it is. a positive COVID case. So first and foremost, you need to instruct that individual to isolate, remove, right? Get away from employees, get away from guests, isolate, and then be removed from the area. Go home, or if possible, depending on the medical necessity, seek medical attention. You're going to need to clean and disinfect that area. So if at all possible, you want to close off the immediate area around where that individual was, wait a few hours, and then begin a cleaning and disinfecting process. If it has been, and this happens a lot, if it has been 3 days or more since that infected individual was in your workplace, the CDC is going to say you're not going to need to conduct any additional cleaning and disinfecting. What you've done, what you do in your normal routine is going to be okay. And again, we see that a lot. And what that looks like is you're going along with work, somebody calls you and says, hey, I was in the office 6 days ago, found out the day after I have COVID, I'm not coming back in. In that instance, we're not going to need to go back, close off the area, do routine or do extra cleaning and disinfecting because it's been over that 3-day window per the CDC. We're also going to need to go and notify close contacts. Again, as we talked about earlier, close to contact is somebody within 6 feet for 15 minutes or more over a 24-hour period. An important point in determining is who are those close contacts is when did this individual become somebody who could spread, right? Becoming their symptomatic or spreading stage. And that is 2 days prior to that individual testing positive or showing symptoms. And this can be a very important factor because if an employee calls in and says, hey, I tested positive and started showing symptoms on, day 1, but that employee hasn't been in the facility for 4 days at that point, you're not going to need to notify close contacts because they were not in the facility, in the workplace in that 2 days prior to their testing positive or showing symptoms. So quarantine and isolation periods, first I think it's important just to know the difference. When we talk about quarantine and we talk about isolation, they are not the same thing. Let's start with isolation. If you have a positive case or a suspected symptomatic case where you have COVID, then you need to isolate. The isolation period recommended by CDC right now is at least 10 days since you first experienced symptoms, and then 24 hours without a fever, without using fever-reducing medicine. You also need to have other symptoms related to COVID-19 start improving. There are some, the kind of exception to that or the note to that CDC provides is certain symptoms such as loss of taste can actually linger a little bit longer. So if an employee has that, you can certainly look at that guidance and make a determination based on the other factors if it's appropriate for them to return to the workplace. But in general, as long as your other symptoms are improving and you've had that 24 hours with no fever, you're okay to come back per CDC. So that's isolation. That's if you've had it. What if you're quarantined? So I never had it. I never gained symptoms, but I was in close contact. So the CDC really from the beginning and still is going to recommend 14-day of quarantine. What CDC has done, I think starting a few months ago, is created shorter alternatives. Now, before you implement either of these shorter alternatives, you do need to check, as with everything, but you really need to check with your local and state county health departments to check if they're approving these shorter options. But if they are, or if they don't mention it, you can go ahead and implement one of these. And what there are is twofold. One, CDC says you can do a 10-day quarantine, right? Instead of 14, no testing, you can just reduce it to 10 if appropriate. They also have a 7-day with a negative test on day 5. So what that means is you have a close contact. 5 days after that close contact, you take a test. Your test is negative. You can end your quarantine on day 7. Importantly, people who do not need to quarantine, right? So we're not talking about isolation, but we're talking about quarantine that you remained asymptomatic, but you had close contact to a positive case. If you are fully vaccinated, CDC says you do not need to quarantine. Also, if you have been diagnosed and recovered from COVID-19 in the prior 3 months, you do not need to quarantine following a close contact. So let's move to OSHA. Very recently, two significant developments announced by OSHA. The first is updated guidance for all employers. And again, this is going to be guidance, so it's not mandatory, it's not a regulation, it's guidance. And this is the first real update we've seen from OSHA since back in January in response to Biden's executive order. And we're going to talk about who that applies to and what the guidance is in a second. The other thing we're going to talk about once we get to our healthcare dedicated portion is certainly something I think many of you have questions and are focused on, which is the new healthcare ETS, or emergency temporary standard. So this, and I think I understand a lot of people's thoughts on the call, which is now here we are in June, and COVID is across the country getting much better, and now we have our very first regulation from OSHA, requirements from OSHA on what you have to do. Again, that's limited to the healthcare industry. So we're going to talk about who that applies to. If that applies to you, what do you need to do once we get to that healthcare section? Let's start with the guidance. So again, here we're talking about the guidance issued on June 10 that is going to cover anybody except those covered by the healthcare ETS. The big change here is its focus. So instead of the past, in fact, the OSHA guidance immediately prior to this said, do not differentiate between vaccinated and unvaccinated individuals. This new guidance entirely focuses on unvaccinated individuals and otherwise at risk, which we'll talk about. So huge shift in terms of what OSHA is advising. Whereas prior to June 10, they really wanted you to treat all employees the same. Now they're saying the opposite, right? And in fact, they're saying if you have a workplace where everyone is vaccinated outside of potential local and state requirements outside of the ETS, you're really not going to need to do COVID precautions, right? All of their guidance is really just focusing on those unvaccinated and the at risk. So what does at risk mean? Really here, and Brad referenced it earlier, what they're referring to, and they reference a CDC document, is people that have an immunocompromising condition. So they've been vaccinated, but they have some condition that might make that vaccine less effective. And one of the important things, that Brad and I have discussed is, okay, well, how do I know? I'm an employer, and now OSHA's telling me, okay, at risk, you need to treat these people, different, special, make sure they have all these precautions. But how do I know who has this condition? We do not recommend, and frankly, OSHA doesn't answer that question, but we do not recommend you going out and asking all of your employees, hi, are you at risk? Do you have an immunocompromising condition? But rather making it in your policies and in your procedures clear that certain rules apply to unvaccinated and otherwise at-risk employees. And then if an employee wants to come to HR with that information, they can, but at least your policies are clear. This is who it applies to. And then you're not going to go individually and ask everybody. I think Brad has appropriately strong feelings on that. Just making sure we're adopting it into our policy, but not reaching out to individuals to solicit that information. Finally, one thing that I wanted to mention before we go on to the specific elements of it is it encourages employers to engage with workers to determine how best to implement mitigation measures. And this was a little bit more pointed than OSHA normally has in their guidance. And so what they're really wanting to do, and this is probably reflective of new leadership in the Department of Labor, but they want you to make sure you're going out and talking with your workers, or if they're represented, their representatives, and making sure you're getting their feedback on how best to mitigate COVID in the workplace, right? Understanding what their concerns are as you're developing your policies. So an overview, again, there are more than we're able to include here, but just an overview of what your COVID program, COVID policies should include per OSHA's new guidance. Is paid time off for employees to get vaccinated, right? There's no requirement or guidance saying you need to make sure everyone gets vaccinated. They do want to make sure you're offering that paid time off. Instructing, as we talked about earlier, consistent with CDC guidance, instructing that sick or exposed unvaccinated workers stay home from work, that you have physical distancing for unvaccinated and at-risk employees. Face coverings, again, while fully vaccinated, we're not addressing here, but for those unvaccinated and at risk, continuing to have face coverings. Maintaining our ventilation systems. This is something OSHA has been talking about for a little bit, and there's requirements in the ETS that we'll talk about. But if you control your workplace, making sure your ventilation systems are up to date and working appropriately, and then again, continuing to perform that routine cleaning and disinfection. And again, there's kind of a real reference CDC guidance for how to do that. One thing that's interesting, the OSHA guidance goes a little bit further for certain workplaces, what they're calling high-risk workplaces, manufacturing, food processing, and certain retail and grocery, right? And they're providing additional suggestions or recommendations for employers in those areas. A lot of them really relate to just trying to make sure you don't have a lot of people in the same place at the same time. So we see staggering break times, right? Staggering arrival times, staggering departure times, all focused on making sure you don't have a lot of employees in the same area at once. Providing signage, posting around your facility, reminding people of physical distancing could be done by floor markings. And then, which is something probably a lot of employers have already done, but if you haven't and you have unvaccinated or at-risk workers in your workplace, making sure your workspace is arranged to allow for maximum feasible distance from coworkers or from the public, right? This could include physical barriers, this could include rearranging a workspace, rearranging a production line, but just making sure you've taken those steps to really, as much as feasible, create that appropriate distance. So while these are just guidance, while these are just suggestions, OSHA has issued citations relating to COVID. Well, how do you do that if you only have non-mandatory guidance? You do it through your previously established standards or previously established requirements. And these are the main ones at issue we see here: general duty clause, PPE, sanitation, and record keeping. General duty clause, if you're not familiar, is a requirement that all employers keep their workplace free of recognized hazards. And what OSHA can do and has done is say, well, if you look at our guidance and you look at CDC's guidance, those are clearly recognized hazards, right? These COVID-related hazards are recognized as laid out in our guidance. So they can use that guidance as a way to kind of bootstrap into a general duty clause violation. So while you don't necessarily need to hit every recommendation, it is very important to go through, review them, implement whatever ones are feasible and make sense in your workplace, so you can show that you've made good efforts to review and comply with that guidance. The next one is PPE, and this has been one of the most frequently cited as it relates to COVID. Under the PPE standard, you need to conduct a hazard assessment of your workplace and determine what PPE is necessary. And so if you have not done that, if they come in, they say, show me your hazard assessment, you don't have one, which frankly several employers don't, that's an automatic citation. The next one that's very common under the PPE standard is respiratory protection, right? Facial covering versus a respirator. A filtering face piece, such as an N95, is technically a respirator, and you're going to have some requirements that you have to follow under the respiratory standard if you're requiring or even permitting employees to wear those N95s. Sanitation, again, there's some general requirements under OSHA to keep your workplaces clean, to have soap in certain areas, so you want to make sure you've reviewed those and you're complying. And finally, and we'll talk about this one in a little more detail because this has been one of the main issues in addition to PPE that OSHA has cited quite frequently, is record keeping. And when we're talking about record keeping, we're talking about our OSHA logs, right? Those records of injury and illness. And we're also talking about reporting obligations. So let's start with record keeping. You have to record work-related COVID-19 in certain situations. And those are if it's a confirmed case, if it's work-related, and if it involves one or more of the relevant reporting criteria. This third one is almost always the case, right? Because it includes one of the relevant reporting criteria is days away from work. If somebody has COVID, as we've already talked about, they're going to have their isolation periods. They're almost always going to miss a day. So the real issue becomes, was this work related? That's a very challenging question, as I think we all know, or anyone who's attempted to determine whether COVID-19 is work related knows, because they're in your workplace, but then they're out of your workplace, they're at home, maybe they're on public transportation. How do you know where they picked up COVID-19? So what you need to do as an employer is investigate each case of COVID-19 from your employees or those you daily supervise to determine if it's work related. And OSHA has given us some suggestions on what to ask, what to look for when doing that. So one of the really important parts of that is talking with that employee, right? Ask them, how do they think they got it? Talk to them about their daily routine. Do they take public transportation? Does anyone at their home have it? And again, in these conversations, you're getting very close, right? And in some cases, actually asking about other people's medical information. So you want to make sure you're doing this respectfully, understanding privacy, not forcing them to answer, but just engaging this conversation about what their routine looks like, where they think they may have had exposure to COVID-19. And finally, you want to review that work environment in your workplace. So for example, where do they come in? Are they around several people during their workplace, or are they in an isolated place where they almost never run into anybody, right? Once you review all of this information, you then make a determination. Do you think it's more likely than not they picked it up in the workplace? If you don't, you do not have to record that on your OSHA 300 log. But if you do think it's more likely not that they contracted it in the workplace, you will need to record that on your 300 log. Reporting. So in addition to recording, OSHA also requires reporting of significant injuries and illnesses. So what do you have to report? Most relevant here, you have to report a fatality or an inpatient hospitalization. But there's caveats to that that are very important for the COVID context. For a fatality, you're only required to report if that fatality occurred within 30 days of the work-related exposure. So if you determine a case is work-related, somebody gets COVID and dies 6 months later, you're not going to need to report that. That's outside of that window. For inpatient hospitalization, it's a much tighter window. It's 24 hours, right? And so if somebody has exposure in your workplace, a week later goes to the hospital and is admitted, you're not going to need to report that because it's not within 24 hours. One thing, just in case anyone needs to drop off, is healthcare ETS for healthcare has changed these specific requirements. We're going to talk about why that's so important when we get there. With that, I'm going to pass it back to Brad.
Thanks, Robert. I think we will, thank you, Robert. I think we will take some of the questions that people have posed and answer those before we dive into the healthcare employers segment of our presentation, simply because some of them relate to both. We have a question, what about the EAU vaccines? Is that the same as FDA approved vaccines? Well, the emergency use authorization is an authorization granted by the FDA. The regulations related to emergency use, I'm not an expert in those, but they certainly require phase 1, phase 2, and phase 3 trials of a vaccine before an EAU or a EUA can be issued. So yeah, I mean, once a vaccine has EUA, it is an FDA vaccine to that degree of review. And I guess I don't know clinically what goes on beyond that for the more thorough FDA review. A question about, I have an employee who is trying to get pregnant. Her doctor advised against the vaccine as they don't know if the vaccine causes infertility. This is going to pose, I mean, you've got your pregnant employees, and then you've got your employees who are trying to get pregnant. And, you know, the clinical data on this is something that I think every employer is going to have to get comfortable with on their own, in the sense of reviewing what they can find about whether there is any clinical evidence to support an effect on either fertility or pregnancy. I hesitate to tell you, my reading simply because I'm not a clinician. And I think those, employers probably need to get comfortable with what they think is the right response for them based on the healthcare experts they can access, either through their health insurance company. Sometimes you can access some expertise, or you may need to go out and retain somebody to advise you on questions related to fertility and pregnancy and the vaccine. I think you've got to do that homework, and then you've got to decide if a person is trying to get pregnant as opposed to being pregnant, are we going to enforce the policy based on what we know about the vaccine? And that's the legitimate way to go about that. Another question: what is the risk for an employer that mandates a vaccine and the employee has a side effect or a reaction? Does the employer bear some liability? Your workers' comp systems in every state will have something to say about that. Employees would need to file a claim under your workers' comp process if they're covered by workers' comp. If they're not covered by workers' comp, I'm not aware of any lawsuits based on employee side effects related to the vaccination. Those side effects are going to be physiological for that employee. They may say, they're not going to be able to legitimately say, I knew I was going to get a side effect because I have this condition. If they have a condition, then they need to request an accommodation for an exception to the requirement. If they go ahead and get the vaccination knowing they have a condition and they don't request an accommodation, then that's a problem in their thought process, not in your policy. So I don't think an out of the blue side effect poses a significant liability risk for employers. You may get some workers' comp claims, but your workers' comp carrier, or in Wyoming, your state system will sort through whether that's a valid comp claim or not.
Brad,
yes.
Sorry to interrupt. Can I add something from an OSHA side?
You bet.
This has been an interesting area for any of you all following OSHA. At first, OSHA had the possibility that you're going to need to record those side effects, right, to the vaccine. If all the other things are checked, if you have to take a day off work because of an adverse side effect to the vaccine, there was a potential to have to record that. In OSHA's latest guidance, they have come out and said that my bad, right? Well, it turns out we forgot that maybe that will create disincentives to employers trying to require people or encourage people to get vaccines, and therefore we take it back. And so from a pure OSHA recording standpoint, as it relates to that regulatory liability, you're not going to need to record those negative side effects on your OSHA 300 log.
Thanks, Robert. A couple of questions about disclosure of vaccination status. The EEOC guidance makes it very clear that an employer can require employees to notify the employer about their vaccination status via a confidential mechanism, either to HR or providing documentation to human resources to be kept in the employee's confidential medical file. You can require that. So an employee who refuses to answer that question is in violation of your policy if you in fact adopted that policy, and you can enforce it. So to the extent the questions, I can see a couple questions here about employees who refuse or resistance to telling you whether they've been vaccinated. You have the go-ahead from the EEOC to require that. You should check your state law. And state law will be changing in various states about this, but right now, unless you're in Montana, you can ask that question. Let's see, a couple of questions that are really pretty clinical. Are you still fully vaccinated if the experts say you need a COVID booster? There's no way to know that today. That's going to depend entirely on what the CDC says about boosters down the road. And so I don't know that there's any way you can predict what that's going to mean for your policies as it stands today. Another clinical question, What about the vaccinated individual that might carry the virus without knowing it and may still be able to transmit it? Everything I've read said that if you're fully vaccinated, your transmission risk is substantially low, very low, almost non-existent low. So I don't know. I have not seen any legal guidance for employers that suggests that you have to protect against the risk of a vaccinated person transmitting the virus to a non-vaccinated person. I think all of the regulatory agencies are treating vaccination as gold standard with respect to transmission risk. Is that your view, Robert?
Yeah, absolutely. Especially from OSHA's standpoint, their new guidance is very clear that if you're fully vaccinated, this does not apply to you, and that employers do not, in almost all circumstances, one of those being the ETS, but in almost all circumstances, you don't need to take precautions to protect those that are vaccinated, fully vaccinated, not otherwise at risk. So while those, I think, absolutely similar to the booster, I think those are absolutely going to become issues in the coming months, if not even sooner. As of right now, from a regulatory standpoint, they're not. If you're fully vaccinated, you're fully vaccinated.
Thank you. And the last kind of general applicability question, do you recommend we integrate these policies into our company handbook or a separate COVID pandemic response policy? I recommend the latter because things are going to continually change, just as they have over the last 6 months. Things are going to continue to change with respect to how employers implement these policies and how the vaccine works, herd immunity, the spread of the disease. All of these things are going to have an influence on how we deal with this on a policy level. So you don't want to reprint your handbook for every change you're going to make in your COVID policy going forward. I'd have a separate standalone policy and revise it as you need to based on circumstances and conditions. All right. So what's that?
So I was going to say, I absolutely agree. And in fact, right, OSHA is going to suggest that you have a written COVID plan. The healthcare ETS that we'll talk about is going to require one. And a lot of states actually, and even local municipalities are going to require that you have a written COVID plan. So keeping it separate, keeping that written plan by itself so you can continue to update it, as Brad referenced, I think is the best practice.
Right. Let's go ahead and dive into our healthcare question. So I want to just share a few general pointers, and the majority of this segment is will focus on the OSHA ETS for healthcare employers that Robert will discuss. But I want to talk about this Houston Methodist case. The Houston Methodist case has been covered pretty widely in the healthcare blogs and the like the AHLA, American Health Lawyers Association. I caution my hospital friends and my healthcare friends from taking this dismissal as for very much weight in the course of your policy considerations. It's one judge's opinion. It was, in my humble opinion, it was not a very thoroughly reasoned opinion. The analysis was pretty limited. It's already been appealed. So the Houston Methodist case is a good win, but it don't put much weight on it going forward, even if you're in the healthcare field. One other thought, I started out talking about state law, and I mentioned the Montana statute. If you're in healthcare, let me break it down into two categories. If you are a licensed nursing home, a long-term care facility, or an assisted living facility, you are exempt from the Montana statute for any period of time in which complying with the Montana statute would cause you to violate CMS regulations or CDC regulations. So if you're in one of those three categories of subcategories of healthcare, you can continue to require vaccination of your employees and you won't be in violation of the Montana law. If you are in other kinds of healthcare facilities in Montana, your facility will not unlawfully discriminate if it asks the employees to volunteer their vaccination or immunization status for the purpose of determining whether your facility should implement reasonable accommodation measures, and you implement those accommodation measures for people who are not vaccinated or not immune to protect your patients. And there are a few other exceptions as well, but the general rule still applies to all healthcare. The general Montana rule still applies to all healthcare entities other than nursing homes, long-term care facilities, or assisted living facilities. So that's something to keep in mind in Montana. All of the state laws that I've looked at that have been considered to have some degree of healthcare exception or some nuances for healthcare employers. So these are going to be a state-by-state issue. When you're considering as a healthcare employer whether to implement a mandatory vaccine policy, as I said before, you doubly need to support your policy with analysis. I caution you not to assume that every position in your hospital or in your healthcare facility must be subject to mandatory vaccination without conducting the analysis to support that. If you have to defend your policy, you will have to defend it based on the employees who challenge it, not your policy-wide issue. Plaintiffs' lawyers will get better and better and more granular in how they bring these challenges, and they will start doing so based on your file, your medical records people who never have patient contact. They're gonna argue that those patients are not should not be subject to mandatory vaccination, et cetera. So that's an example of the kind of arguments that we're going to begin seeing. The Methodist, the Houston Methodist plaintiffs lawyers, they took sort of a shotgun approach on behalf of all of the 117 people who refused. I don't think that's how all these lawsuits are going to be brought. So the analysis, the granular analysis is going to be important. You're going to have to review your policies as circumstances change, and circumstances within your own institution as well as within the population at large. So, so kind of calendar, if you will, a monthly or quarterly roundtable about whether our policy still applies to what we have today. I think in reading the OSHA standards and the CDC guidance, I think we're as healthcare employers, you may be in a position where those guidances sort of effectively overrule some of your policy anyway. You've been operating for months prior to the vaccine with a variety of measures that were dictated by CDC and dictated by OSHA. And it may be difficult for us to argue why those infection control measures are not now an effective accommodation for those people who do not wish to be vaccinated. And so that's what I mean when I say, we might be in a situation where it's going to be difficult for healthcare employers to walk away from the things that have been keeping patients safe for several months, because we don't have to do those anymore, when we argue that we don't need to do those things to accommodate an exception to our mandatory vaccination policy. I think anti-vax opinion and bias are going to be special challenges for healthcare employers. I think healthcare employers are far more likely to see negative reactions to non-vaccinated employees from other employees, and because two of the reasons for non-vaccination are disability or religious reasons, those reactions can very quickly turn into disability or religious harassment concerns. So I think you'll need to be especially attuned to that as a healthcare employer, because everybody from your certified nursing assistants up to your chief medical officer are going to have strong opinions about vaccinations. So those opinions can be problems for you as an employer. The other thing, if you're a public institution, the Constitution protects your employees and their ability to speak freely on matters of public concern. So your nurse in your ICU can send a letter to the editor saying, I'm in healthcare and I don't think people should be vaccinated because I think the vaccine is XYZ. And you cannot take action against that nurse, even if she contradicts the public physician of your public hospital. Now, if your chief medical officer does that, or your human resources director sends emails to employees saying, I don't think you should get vaccinated even though the boss wants you to, those are different cases. But you need to be careful about reacting to your employees' free speech on the issue of vaccination if you're a public entity, if you're a governmental hospital. Because these state law issues are going to come at us fast and furious, I really encourage you to engage your legislators on this topic directly. In our Western states, we can often do that very directly. If not, use your associations to do that. That's where we're going to see the primary source of restrictions and liability in these cases when it comes to vaccinations for healthcare employers. And that's where you're going to be able to carve out the exceptions to those statutes that will work for you as a healthcare provider. So let me turn it over to Robert again to talk about the ETS.
Thanks, Brad. Right, so our new OSHA healthcare ETS. Let's start with application. Its general application is quite broad, right? It's going to say it applies to all settings where an employee provides healthcare services or healthcare support services. And you can see the definitions on the slide there, but it's essentially if you have services by professional healthcare practitioners for really any purpose relating to health, right? It says promoting, maintaining, monitoring, or restoring health, you're going to be covered by this ETS. And then there's also support services that tie into that, right? So a pretty broad application by its plain language. One thing that's important to note, this also can include a healthcare setting in a non-healthcare setting. In other words, if you have a large manufacturing facility and there's a clinic inside that manufacturing facility, that clinic very may well be covered by the OSHA ETS. It doesn't mean the entire manufacturing facility is, but it means that clinic may be. Brad, can you go down to the next slide? I don't have control of it.
There we go.
Oh, there we go. Got it. So with that broad application, the important thing is going to be, do I fit into an exception? Right? Almost everybody who's in healthcare probably falls into that broad definition. So the next step is going to be, all right, let me look at the exceptions to see if I fit into one of those. And therefore, even if I fall under that healthcare definition, I won't be covered by the ETS. So first one is first aid by a non-licensed healthcare provider. So if you have somebody at your workplace who's not a licensed healthcare provider, but provides first aid to somebody, you're not going to be covered by the ETS. Giving out prescriptions by pharmacists in a retail setting, not covered by ETS. This next one is a big one that based on clients I've already talked to, I think is going to be really where a lot of employers try to find exceptions. And that is ambulatory care settings where non-employees are screened and people with suspected or confirmed COVID-19 are not permitted. So let's break that down a little bit. Ambulatory is essentially, there's a full definition in the new ETS, but what we're talking about is outpatient facilities not being admitted into the hospital, right? This could be, a radiology facility, a whole host, but this outpatient non-admitted into the hospital settings. And so in these settings, if you are screening, obviously employees, that's separate, but non-employees, right? So any patient before they come in, if they're getting screened and those that are suspected or confirmed with COVID-19 are not being allowed in, you're not providing them services, you can be accepted from the ETS. If you're in a hospital setting, you're still in ambulatory care, but you're in a hospital setting, you still can be accepted from the ETS, but you also have to have the additional requirement of that all of your employees need to be fully vaccinated to meet this exception. So those are two large ones that you'll need to look at closer if you do fit into that ambulatory care setting. There's also home health care settings where your employees are fully vaccinated. And similarly, non-employees are screened, right? And people with suspected or confirmed COVID-19 are not present. So similar, and you're starting to see this theme here, right? So what OSHA is saying with these exceptions is If you've got a workplace where you're going to have, almost no risk of anyone coming in with COVID-19, there are exceptions that may apply to you, and that can include home health care. Healthcare support services. So what this is really talking about is people performing, kind of support to healthcare, but it's not in a healthcare setting and there's no direct patient care. This could be laundry, billing, accounting, anything along those lines that's done separate in an office away from where actual healthcare is being performed. And then finally, telehealth services without that direct patient care are going to be accepted from the ETS. So those are our main, and when you're taking that first step, those are really where you want to start to see if this even applies in the first place to your facility. So the regulation is 42 pages, so we're not going to go through each line of what's required, but I did want to give an overview of its requirements, just to give a heads up of what you'll need to look at if you do fall into its scope. First, you're going to need a COVID-19 plan. If you have over 10 employees, that plan is going to need to be in writing. And that's going to include a hazard assessment specific to COVID-19. And what we mean by hazard assessment is you are looking at your facility, you're assessing your facility and looking for any potential hazards relating to COVID-19. You're going to need to set up policies and procedures for patient screening, patient management. You're going to need to set up policy and procedures for standards and transmissions-based precautions. There's a CDC document that's referenced in the ETS that provides guidance on that issue. You're going to need to have PPE policies, and that's going to include face masks. It's going to include respirators, depending on the certain situation, as well as additional PPE, depending on your hazard assessment. If there are aerosol generating procedures or AGPs, there are special protocols you're going to need to put into place. Physical distancing, this one is an interesting one to read. It says you need to have 6 feet of distance between employees and others when feasible. Obviously, in direct patient care, that's not feasible, but you're going to need to evaluate the tasks that happen in your facility and try to the extent feasible, create the most physical distance. You're going to have significant cleaning and disinfection. That's all laid out in detail in the ETS, but you're likely going to need to update your policies or practices based on the requirements in ETS. Ventilation is one that I think strikes some people. If you are controlling your facility, right, you have control over that ventilation system. So you own the building or you control the building. There are steps you're going to need to take to make sure your ventilation system is working. You need to make sure your air filters meet a certain level if they work with that HVAC system. So there's going to be some significant evaluation of that ventilation system and what goes into it and how much it's circulating air from the outside. That all is going to need to be done as part of meeting this ETS. Then there is significant employee health screening and medical management requirements. So this is going to be everything from your policies of employees need to notify you if they believe they may have COVID or symptoms. You need to notify others if somebody in the workplace has COVID. There's an exception here if you are a facility that routinely treats people with suspected or confirmed COVID. That's not going to trigger the requirement. But other than that, you're going to need to notify people who've had that close contact if they weren't wearing a respirator of their close contact with someone with COVID in the workplace. And then it's going to lay out steps for when you need to remove people from the workplace, how long they need to be removed based on their close contact or based on their symptoms. A lot of that is going to reference CDC guidance. It actually incorporates a fair amount of CDC guidance into this ETS, especially around removal and time back. Vaccination, it does not require vaccination, but similar to what we saw before, it's going to have some requirements on providing time off and encouraging vaccination. There's also significant employee training requirements. So you're going to need to make sure your employees are trained on COVID-19. What is COVID-19? How is it spread? What are our internal policies to prevent and mitigate the spread? And that's everything from going over your PPE, your self-screening requirements, etc. Record keeping, like we talked about before, and here's a big, but the big caveat that I referenced earlier, the limitations on time that we talked about. So, right, if it's a fatality 30 days within the exposure, if it's an inpatient hospitalization 24 hours within that, from that work-related exposure, those are specifically exempted from this. So in other words, if you have an employee or somebody you supervise on a day-to-day basis with a work-related hospitalization or a work-related death related to COVID-19, you're going to need to record that. You're also going to need to create a COVID-19 log. This is different than our 300 log. And what this is going to do is you're going to record, whether work-related or not, every instance of employee COVID that you have. And that's going to allow you to track it and better determine, when it is work-related or not. But so you're going to need to create a log of your instances of COVID in your workplace. We've got a little bit of formatting error here. Some of the boxes were duplicated, but the other one we want to mention here is a mini respiratory protection program. OSHA already has a respiratory protection program. This is now another one that's really going to apply in instances where you're not requiring a respirator, such as N95, but you're providing them for voluntary use, or an employee is bringing them in and wearing it because they want to wear their own. You're going to have certain respiratory protection, what they're calling their mini respiratory protection program requirements in those instances. So all that to say, there's a lot, right? And I already have received, and I certainly understand some frustration when it looks like, starting to move our way out of this, that now all of these new regulations are put into place for the first time. But to break this down, the first thing you need to do if you in any way provide healthcare services is look at the scope of your facility and really look at those exceptions. Reach out to us, happy to help with those, but look at those exceptions and see if you're going to fit into one of the exceptions from the ETS, such as those certain home healthcare situations or ambulatory care situations we talked about earlier. If you're not going to fit into those, right? And that's going to be essentially if you have a workplace or a healthcare facility that is treating, testing, interacting with, providing services to suspected and confirmed COVID patients, you're likely not going to be an exception. So if you're in that world, then you're going to need to go through, look at all the requirements that I just overviewed in the new ETS and make sure you're meeting. This is different than what we've done all the way up till now with OSHA, unless you're in a certain state that has more specific requirements, where we've looked at the guidance and we've said, okay, what fits best for me? What makes sense in my workplace? I will do this, this, and this. This guidance doesn't really make sense to me. I'm going to not do that. We can't do that anymore. This ETS is a requirement, completely mandatory. We have to follow every item in here, or we're subject to regulatory liability, specifically a citation from OSHA. And also from a civil standpoint, if we're not following these, it can be extra ammunition for plaintiffs' attorneys as they're trying to build cases, maybe against a hospital, say, look, OSHA put out what healthcare facilities are supposed to do. They weren't even following. This was published and went effective yesterday. So this is now an effective regulation, but we have some time before the compliance dates hit. Our first date is July 5, and that's where we essentially need to comply with everything except physical barriers, ventilation, and training. And so that's going to allow us a little more time if we need to go out and buy more physical barriers, if we need to conduct some maintenance on our ventilation system, provide us a little bit more time, but everything else, we're going to have to be up and going on July 5. And then July 21 is the date where we need to have everything else in place, full compliance with our ETS.
All right, Robert, we've got a few more questions. We are just about at our 1:30 end time, but I think we can handle these. Question, is there a limit on how much and what data elements an employer can collect regarding COVID vaccination status and where, how it is stored? Let me answer the second part first. Because it's declared to be confidential medical information, the data needs to be stored confidentially that can be stored. I mean, you can keep it in a spreadsheet where you have everybody's information, but that spreadsheet needs to be access controlled and confidential to, human resources or to the employee health nurse or something like that. The question about how many data points about the vaccination, there's no guidance on that. I would suggest it's pretty limited. I mean, I think you could request date of vaccination, location of vaccination, the vaccine that they received. I think you could request those data points, and if it's one of the two-dose vaccines, you could request the date of both vaccinations. So I think you are able to ask those questions. I don't know. I'm not sure what else you might want to know, but I think you would not go wrong limiting it to that data. Question: the Montana statute is getting some attention here. In Montana, for healthcare employers, can we ask if employees are vaccinated, or ask non-vaccinated employees to wear N95s for the entire shift? Yeah, if you are not a nursing home, long-term care facility, or assisted living facility, and you are in some other healthcare facility, you may not require employees to tell you. You can encourage employees to volunteer their vaccination status, and you can then, if they refuse to tell you, you can treat them as though they are unvaccinated, which means you can require that they wear infection control devices in preparation, including N95s, if that's what you're requiring people to wear for infection control purposes. So you're not going to be able to do something harsher for people that refuse to answer your questions than you are for people who tell you that they're not vaccinated. But you need to be consistent across the board with that. Two home care questions, which I think are very interesting. There's one short question: what about home health care? I think that must be a Montana related question. The statute does not carve out an exception for home health care. And I can see where home health care poses some very unique challenges in complying with the Montana statute. The other question related to home care is: when consumers request only vaccinated providers provide care, can this be identified outside of the confidential file for scheduling purposes? I would assume there's risk if this cannot be identified. As a practical matter, this goes back to one of the things I said earlier, which is your risk happens here when somebody gets fired. That's where your risk profile goes up considerably. If you're in home health care and you have patients who are saying, I want a vaccinated provider, I would suggest you find a way as confidentially as possible to match your vaccinated providers to those patients. I think if you did that in a confidential process where not every supervisor has the list, you could probably make a good argument that you're still in compliance. And something, even if there's some risk associated with that, I'd do it anyway, because that's an important factor in providing care to those home health patients, almost all of which are more vulnerable than perhaps other patients are. So, there's times when regulatory uncertainty, you have to turn your back on regulatory uncertainty for doing the best thing for your patients, and I think that's probably one of them. Okay, seems like you've been busy typing.
Yes. I think I see one, Brad, if I can jump in.
Yeah.
It says our industry is not required to complete an OSHA log. We need to start doing this. If we have staff wearing an N95, are we subject to respirator regulations? All right, so to take that in two parts, if you're covered by the ETS, so if you're not covered by the ETS, no, you're not going to have to. If you don't have to right now have 300 log, you're not going to have 300 log. Reporting requirements, though, everyone has to do, but recording, if you don't have to create a 300 log and you're not covered by the ETS, that's not going to change. If you are covered by the ETS, you're not going to necessarily now have to create a 300 log if you weren't before, but you are going to have to create what they are calling a COVID-19 log. And that is going to record each instance identified by your facility of COVID-19 in the workplace to an employee. So you are going to need to create that log. As it relates to reporting, so if you have an inpatient hospitalization, that you are also going to have to do as well. So you're going to have to report fatalities and inpatient hospitalizations directly to OSHA. As it relates to if you're having staff wear an N95 mask, you are subject to the respiratory standard, and specifically if you're by the ETS, you're also going to need to look at the mini respiratory standard as well.
All right, and the last question I see is about a template or a starting place for COVID policies and procedures. You know, there are several good ones that public hospitals have published on their websites. You know, I think I'm not going to recommend any particular one, but you know, Google will help you find a variety of examples. When you start with a template, that's a starting point. That's not an ending point. Obviously, I would recommend you have your counsel review it when you get close to final form, and help you with some of those very institution-specific questions that we've discussed today in general. So thank you, all of you, for hanging with us and for attending our webinar. I know Robert and I have enjoyed doing it, and we hope it's been useful to you. The slides and the presentation, I believe, will be posted on our website, and I believe Misty or Chelsea will send to all attendees a link to where you can find these things. So thanks again. Best of luck with dealing with these changes that are coming at us all like water from the fire hose. You can count on the fact that we'll be back to do our best to explain the next round of changes to you as well. Thank you.
Yeah, thank you, everybody. Greatly appreciate it. Have a wonderful day.